If your landlord uses the wrong form when attempting to sue you in housing court, can your whole case be dismissed? Today, we're covering another housing court hack. Welcome to the Tenant Law Podcast, where all types of New York City tenants can learn about the laws that affect their apartments. Rent-stabilized tenants, free market tenants, good cause tenants, luxury tenants, loft law tenants, co-op shareholders, subletters, roommates, co-livers. Let's all learn to live better. I'm Michelle Itkowitz. First, as always, let's set the stage with some context so you have the background you need to understand today's case. When a landlord wants to evict a tenant or sue a tenant for rent, the most common way to do that in New York City is with a special type of lawsuit called a summary proceeding for the recovery of real property. We call it a summary proceeding for short. Other synonyms people might use for summary proceedings are non-payment case, holdover case, eviction case, landlord-tenant case, housing court case, but we're going to call this type of lawsuit by its real name, a summary proceeding. Summary proceedings are created by and governed by a statute called the Real Property Actions and Proceedings Law, specifically Article 7 of that law. There are two types of summary proceedings, a non-payment proceeding and a holdover proceeding. The differences between these two lawsuits, that doesn't matter for our purposes in this episode today, only that there are two different types of summary proceedings, a non-payment and a holdover. Summary proceedings are brought in the New York City Civil Court and sections of that court called housing parts. This is what people are referring to when they are referring to housing court. In a summary proceeding, the person bringing the lawsuit, the landlord, is called the petitioner. And the people getting sued, the tenants or occupants, they are referred to as respondents. A summary proceeding gets started with two very important documents, a petition and a notice of petition. The petition is the document where the landlord explains to the court why the court should order the tenant to pay the landlord and or why the court should order the tenant's or the occupant's eviction. The petition must also define who the landlord is, define who the tenant is, identify the apartment that's the subject of the summary proceeding, and state whether the apartment is subject to any other form of regulation, such as the rent stabilization law or the good cause eviction law. And the petition does some other things too, but basically the petition is the landlord's story in the case. The notice of petition is a notice from the court to the tenant, although it gets prepared by the landlord. The notice petition tells the tenant that the tenant has been sued and that the tenant must come to court and put in an answer to the lawsuit before a certain date, because if the tenant fails to come to court and answer by that date, then the landlord will win by default. So the notice of petition is obviously pretty important. It's so important that the court decided to make rules about the notice of petition and what it should contain. At Uniform Civil Rules for the New York City Civil Court, Section 208.42, the court created some specific forms that a landlord must use for the notice of petition. There's one for a non-payment case, there's one for a holdover case. And these forms created by the court, they do more than just inform the tenant that they've been sued and that the tenant must come to court and put in an answer to the lawsuit before a certain date, although obviously that's tremendously important. But these forms created by the court, they actually do some other things. The forms also alert the tenant that in some cases, the tenant may be entitled to free resources. And those free resources include legal help, language translation help, help in the courthouse for people with disabilities, financial help, and the court's notice of petition form explains where to go for that help, both in person and or online. The court's notice of petition form also has specific language included about the tenant's rights to an adjournment and some other stuff as well. And the court's notice of petition form also has a little box with a bit of important information in 9 different languages. Okay, so that's the background you need to understand today's case. Today's case is called Locasio versus Villa. It's a February 2025 New York City Civil Court Kings County decision, which I will put a link to in the show notes. Now, in today's case, the landlord or its attorney did not use the correct notice of petition form required by the court rules. So the judge held that this form added new required language that must be included on a notice of petition, such as how to access free counsel, the ability to request an interpreter or a disability accommodation, and the tenant's right to request an adjournment of the initial appearance. The amendment also mandated that after September 30th, 2019, landlords are no longer allowed to create their own notices of petition and must instead use the one included on the court's website. The judge continued to say, the tenant moves to dismiss this proceeding because of the defective and outdated notice of petition served. That motion is granted. The failure to comply with the substantive changes promulgated in the amendments requires striking of the petition and dismissal of the action, even if landlord were able to demonstrate that the lack of compliance did not result in prejudice to the tenant. What the judge is saying is, even if the tenant made it to court with the incorrect notice of petition that was served to the tenant, and even if the tenant wouldn't have qualified for any of that free help, it doesn't matter. The case is still dismissed because the court doesn't want to look every time that a landlord uses the wrong form and go through this whole exercise in figuring out if it actually did any harm. If the court has a rule and you're supposed to use a certain form, you have to use that form. And failure to use the form is going to mean the end of the case. I'm going to read a little bit more from the judge because it was a very well-written decision. In an effort that should be applauded, the amendment to Section 208.42b uses easy-to-understand language explaining to tenants what they are looking at, what the court case is about, the rights they have in defending themselves, and the resources available to help. The notice served by the landlord omits some of these rights and misstates others. The amendment was made to ensure that tenants who receive these documents, many without legal background or prior experience in court, know what is happening and are assured that their rights will be protected if they appear to answer the allegations in the petition. Here, the notice of petition failed to apprise tenant that he would be given access to counsel and incorrectly stated the consequences of paying after a warrant has issued. Today's case brings up some pretty important tenant takeaways, but first, let's just get the housekeeping out of the way. This is not legal advice. I'm not your lawyer, but because I am a lawyer, this might be considered legal advertising. If it's legal advertising, it's just terrible because I'm asking you not to contact me. This pod is not a commercial for me or my law firm. This is simply the podcast that I always wanted to make. Let us know what topics you would like to hear more about. Please subscribe and give us the highest rating. It's time for the tenant takeaway. Tenant takeaway time. If you get sued via a summary proceeding, check the link in the show notes for the notice of petition forms that your landlord was supposed to use, or just look them up on the New York City Civil Court website. Remember, there are 2 different notices of petition, one for each type of summary proceeding. There's one notice of petition form for a non-payment case, and there's one notice of petition form for a holdover proceeding. Compare the required form carefully to the notice of petition that you were served with. If the notice of petition you were served with differs even a little from the court's form, then include that in your answer to the lawsuit, and that may be enough to get your case dismissed. However, I really want to emphasize here that such a dismissal will be on a procedural defect, not on the merits of the case. This is episode 49 of the Tenant Law Podcast, and including this episode, this will be my 4th episode that can be described as a housing court hack. Ways to spot sort of hidden procedural defects that may lead to the dismissal of the summary proceeding against you. And frankly, those have been some of the most popular episodes. You know what? I'm going to just briefly touch on what the other 3 episodes were. Episode 3 was called, Can I Gain Leverage in Housing Court If My Landlord Describes My Apartment Incorrectly? Episode 21 was Housing Court Leverage Tip for Tenants. Landlord can only sue for the monthly rent, and that rent must be properly itemized or the case can be dismissed. Then episode 38 was Housing Court Hack. How to get your case dismissed if your landlord's ownership entity is in bad standing with the state. I like long titles, don't I? Anyway, I'm going to put links in the show notes to all these housing court hacks. Again, what these episodes have in common is I'm pointing out otherwise hidden to the naked eye procedural defects that might be there, that if they are there, can quite possibly lead to the case being dismissed. But crucially, very crucially, here is where we bring it all together in the tenant takeaway. This is the part really worth listening to. All of these types of things are you winning a battle, not the war. You're getting the case dismissed. These are procedural defects. But just because your case is dismissed, like for instance on the wrong notice of petition form basis, that doesn't prevent your landlord from bringing another case against you immediately on the same grounds, this time using the correct notice of petition form. Because your case is dismissed on a technical basis doesn't mean that the rent is not owed or that the lease is not terminated, or in other words, whatever your underlying alleged problem is, that has not gone away. Only the current case has gone away. So let's think about this for 2 seconds. If time has intrinsic value for you, if time is all you really need, then these kinds of things can be very valuable tricks. Exploiting any procedural defect can be if time is really what you need. Maybe you need more time to collect the money to pay the rent. Maybe you need more time to move. Maybe you want to get to the end of the school year or through the Christmas season or whatever milestone you need to get to. So if time has inherent value for you, then getting your case dismissed to buy more time, that could be a good thing. But if more time is not your number one goal, then getting the case dismissed on a procedural defect, at the very least, could possibly create substantive leverage for you. What do I mean? Let's say your really big issue is you wish that the arrears, the rent arrears, would go away so that you could use your available resources to move to a cheaper apartment. That's a very common sentiment these days. So you could use your procedural leverage to maybe say something like this to your landlord. Let me give you an example. Hey, Ms. Landlord, your lawyer does not even know what forms to use. Rather than spend more money on that genius to roll the housing court dice again and waste more time, spend some money on certainty and speed, and let's make a deal. Forgive my arrears. You're not going to collect them anyway. And give me another 2 free months, and I'll get out at the end of the 2 months. That's a method for turning procedural leverage into a substantive reward. And you can do that with any procedural defect, or at least you can try. Now, then again, let's just keep thinking for a minute here. If you're already having a constructive and respectful dialogue with your landlord in the context of your summary proceeding, and that feels like it's leading to a mutually beneficial settlement, then it's always possible that getting the case dismissed on a procedural defect could sour that atmosphere. So maybe you could raise the issue, but not get the whole case dismissed. Look, here's the thing. There is no one right answer for how to best utilize a procedural advantage in housing court. It depends on your goals and on your circumstances. My self-appointed job here in this podcast is to let you know that you even have such options and to leave you with some suggestions of how you might utilize those advantages if you have them. And there you have it. Remember, New York City, the law belongs to you, but your ownership of the law is only as great as your understanding of the law. So let's learn to live better. I am Michelle Itkowitz, and this is the Tenant Law Podcast.